Good evening, Mackenzie students, faculty members from Dayton School of Law and Mackenzie Presbyterian University. We are glad to welcome you to our third webinar series regarding our joint dual degree program. Tonight we have with us Professor Adam Todd, who is a professor of lawyering skills and the coordinator of human rights collaboration at the University of Dayton School of Law. And we are also proud to have with us the well-known Professor Bianca Richter, recently awarded with her PhD with summa cum laude. And we are also joining us representatives of University of Dayton, Margaret Ioannidis and Walter Haas, and also Mariana Baeta, who is the head of international affairs at the law school. This webinar will be about law and technology. Professor Adam Todd will talk about the law and Internet of Things, up-to-date subject, and Professor Bianca Richter will talk about a case study regarding Airbnb. Everyone is willing in their vacation to go out and seek a nice destination of their dreams. So Airbnb has been on our radar. After both presentations, there will be a moment for questions and answers. And after that, Professor Margaret Ioannidis will talk about our joint program, our online LLM. Tonight, we have also launched and promoted the Law in Americas Fellowship. We will be here also to talk about the program. Thank you very much. I will pass the floor to Professor Adam Todd. You're welcome at Mackenzie Presbyterian University, even though it's online for now.
Thank you so much, Pedro. It's a true honor to be here and to talk about this pressing subject, one that's of great interest to me, but also to my students. I teach a course called Law and the Internet of Things, and just the title, you can tell this is a very broad subject. In my course, I try to accomplish many things, and let me preface by saying, I think unlike Brazil and many other countries, law students in the United States generally don't take international law as a course. And so my course has to touch on topics of international law and give them an introduction to some of these concepts. Fewer students in the United States take any type of comparative law. And so, again, this course tries to touch on some comparative law issues. And then finally, very few students in the United States take jurisprudence as a course. And I say the law that's discussed in my course, but when you think about law and the Internet of Things, it has this jurisprudential question that's raised is, what is the law and how does the law work? Really, is there a law of the Internet and the Internet of Things when there is such change and fragmentation and lack of enforcement? And so there's two central concepts I want to address tonight. One is the law that you find regulating the Internet of Things is multi-layered, and it's regulation that's done on many different levels, and these multiple levels then create a form of constitutionalism that's called a number of scholars call it digital constitutionalism. And so I'll be touching on these two themes in tonight's presentation. So if you can move to the next slide, please. So very quickly, let me just clarify what the Internet of Things is. When the Internet was developed, the Internet was primarily used for people to communicate with other people. so people would send emails, people would send documents to each other, data to each other, but it was really a people to people or people internet of people. Over time, machines were used to send information to people, and then again over time, machines began to send information to other machines, and so we've reached a stage where the internet has more connections between machines, between things communicating with other things, as opposed to people communicating with other people or people communicating with those things. The internet now is not really controlled or functioning as something that in some ways arguably even serves people. It's become more and more of a place where things are communicating with things and advancing a jurisprudence or a society of things. And I think the key or the one of the most significant components of machines communicating with other machines is the data that's produced and the information that is gleaned from that data. And so if you can move to the next slide. The next slide, please. The next slide. Deanna, is it possible to get the next slide? Not seeing it. Oh, looks like we may be stuck. So let me give some examples. It looks like the slides are not going forward. So some obvious examples of Internet of Things devices that many of you may be familiar with is something like cameras. They have doorbells now that have cameras on the doorbell, and those send the information through the internet and sends communications to people's cell phones. There's things like thermostats in houses that regulate the temperature in the house, and that sends information about how many people are in the house, the temperature outside. These devices, these machines, are sending information through the use of sensors. And those sensors, for example, just on something as simple as a thermostat, are extremely sensitive and can gather enormous amounts of data, even that's just one simple Internet of Things device. The thermostat functions to determine whether not just the temperature, but also whether there are people in the room, in the house. And if there are people present, if it detects motion, then it will potentially raise the temperature, or potentially will lower the temperature. And so the detection of not only movement, but also it senses vibrations. And so those sensors can determine whether or not only whether people are in the house, but the time of day that those people are in the house. And because of the sensitivity of the sensors, whether there are different people in the house. So just the one device, just one thermostat can basically give data to a company or to whoever's looking at that data as to the number of people in the house, what time they enter the house, what time they leave the house, what time they go to bed, usually what they're doing in the house. If they're using the oven, that will raise the temperature. So that's just one device. If you think about then, Deanna, if you're possible to go back just one slide. Can you go back one slide? Well, it looks like it's not working. So you not just have one Internet of Things device, a thermostat, across a city. you have almost every house with multiple Internet of Things devices, then office buildings having even more of these Internet of Things devices, streets, electric companies, businesses, airplanes, cars. And so you have this sort of tsunami of data that's being collected that gives information about the way that our world is functioning. And this growth of the Internet of Things is seen as really the sort of the next stage of our sort of industrial revolution. We are entering into a sort of new phase of how we not only interact with things, but how we interact with each other. And as a result, the regulation and the development of law becomes particularly tricky. Yeah, so you can see from this slide, you know, the Internet of Things are ubiquitous. If you can go forward to the next slide. Internet of Things sensors are getting smaller and smaller. In fact, you can't see them in many places now. And so again, the use of these Internet sensors are again growing and are going to be in all aspects of our life. Next slide, please. And again, going into space and all across. Next slide, please. And as I mentioned, there's going to be huge growth. A couple of things to note. We have the development of a 5G network, which means internet connections and internet connections between machines are going to be much more rapid and growing. And then you also have the increase in the number of internet addresses, the IP addresses. Two things to note about these enormous changes. These changes are not because of law. It wasn't a government regulation or a statute or even a court decision that made these changes. These are technological changes that are coming from below, from private industries, from technological groups. And so, for example, IP addresses. IP addresses are crucial for the internet to work. People have to communicate through IP addresses. That mechanism is not done through law, or it's a form of law. It's done through an sort of international consortium, an international group of people who got together, set these standards, and these standards then now are being adopted. But it's not it's sort of not technically a government that ultimately set the growth of the Internet of Things use of these addresses. So I'm going to use that as a platform to talk about them. How do we go about then actually regulating, or what does this regulation really look at? So if I can get the next slide. So let me just state the obvious. So Internet of Things, the Internet itself, there's just tremendous benefits. The economic efficiency alone, we have labor, some money being saved, just the savings in electricity and fuel that a thermostat can provide. In some ways, the benefits of these internet devices are obvious. We've seen vast improvements in people's health through these devices. My father had a pacemaker placed in that was connected to the internet, and it told his doctor when his heart was working effectively and if it was not working effectively. The ability for capital to be communicated through these Internet of Things devices and spread the potential of really revolutionary change to the positive exists with the Internet of Things. If I can get the next slide. Of course, though, I think we also know that there are significant problems. The privacy and cybersecurity risks, I think all of us are aware of these issues, and also, if you're like me, particularly frightened about the level of invasion of privacy and also our vulnerability to things like ransomware and hacking that we've seen, for example, in the United States just very recently. A couple of other things, though, in terms of regulation with the Internet of Things that are important to keep in mind. The Internet and the Internet of Things can only work if machines are interoperable, if they can communicate with each other. And so you need agreements, or you need some form of regulation to allow for this communication. And so whether networks are going to be open or closed or restricted is a part of the regulation, and also the need for regulation with the Internet of Things. And whether something is open and closed, and the access to these great benefits get to important legal issues such as private contracting, licensing, intellectual property rights, and all of those things are wrapped into whether there can be enforcement of forms of regulation that would allow for the operation of this very complex system. Privacy and cybersecurity raises, I think, one of the larger, broader concerns, which is the control of Internet of Things devices, but also the data that these devices can collect, allow for social control. And we see this through social media, but also through the ability to shut down access to things like healthcare or access to capital. And that allows for then a growing possibility of economic and social inequality. And also it puts us all in some ways at risk, not only for in terms of control, but also just whether the products themselves can be trusted. Can we really rely on the Internet of Things to make our lives better when there is this promise for these great benefits that Internet of Things can ultimately provide? Next slide, please. Next slide. Possible to get the next slide.
Here we are at governmental oversight.
Okay. That's so good. Okay, great. Thank you. In terms of the regulatory approaches, let me best back up. The prior slide gets to sort of, there's three possible futures for the Internet. One is the Internet breaks down and is fragmented, and we don't gain the benefits that the Internet of Things promises, or we can regulate and control the Internet of Things to bear the fruits and maybe get to a utopian a way of living where we can things are healthier, things are more equal, the environment is cleaner. And so right now there's different regulatory approaches that are not all consistent. You see sort of very strong governmental regulation in countries like China and Russia, which I would call the sort of authoritarian approach to governing the Internet and the Internet of Things. You have a more comprehensive form of regulation. I call this sort of the modernist approach. You have a comprehensive, coherent framework like you find in Brazil through that looks to regulate the Internet and also the data that is being provided by the Internet. The European Union is also obvious, good comprehensive model for that. In contrast, though, you have the United States, which I would call a postmodern approach, which is fragmented, incoherent, changing, and I use the word postmodernist not pejoratively, but not in a good way either. You know, postmodernism has its drawbacks, but also it's a useful frame to see how fragmented regulation is also a good label for the way that the Internet of Things is being regulated today. So if you can get to the next slide. So here, just this slide gives you an illustration of the lack of coherency and the fragmentation you find in the United States on just laws relating to data and data protection. There are dozens of laws looking at different aspects of the collection of data. For example, there's different laws for just the data for children compared to data relating to companies that rent movies compared to companies that do financial services, and there's not coherency between these regulations, and then on top of it you have differing governmental entities that are regulating these different sectors, and again there isn't an overall sort of coherency between these different agencies, and so the lack of coherency I think is particularly problematic in the United States. I think you find it internationally as well. The only argument in favor of a lack of sort of commonality or sort of comprehensive regulation is that it allows for flexibility and also allows for more self-regulation. And so the United States, in many ways, prides itself on allowing the market pressure and self-regulation to drive much of what is the regulation of this area of the law. If you can move to the next slide. So this gets to then this idea of digital constitutionalism, or constitutionalism being a frame of looking at how not only the United States but maybe other countries are regulating the Internet of Things and the Internet. But also, if we step back in how, because the Internet and the Internet of Things is not a national phenomena, but it's a transnational issue and phenomena, something that really can't be captured by a single country's laws. The frame of digital constitutionalism gives us a greater insight into not only how the Internet of Things is currently being regulated, but maybe how it should be regulated in the future. So, next slide, please. So with digital constitutionalism, or looking at the way that the Internet is controlled sort of broadly, with and looking at all the factors and actors that are regulating or controlling the Internet of Things, a number of things come out. We have this fragmentation that I mentioned about, this disjointed goals across different countries, difficulty of enforcement. I think those are all obvious. But you also notice that if we're trying to regulate across boundaries in terms of international boundaries, the Internet of Things and most regulations oftentimes have a Western or industrial orientation and value system that doesn't always jive with necessarily the values of all countries and all, and so there's a concern that there's an entrenchment of inequality, and that the beneficiaries, the stakeholders of the Internet of Things, will not ultimately be the beneficiaries of the benefits of the Internet of Things. So looking at at is the regulation one that's merely entrenching the problems that we find in today's society, or are they actually working towards getting us into someplace better? So let's look at the next slide. I'm not seeing the next slide. Mike, I'm not seeing the next slide on my screen.
Professor Adam, we are at the multi-layered exercise of power.
Okay. All right. Thank you. I'm not seeing that. Okay. So yeah. So okay. Here we go. I got it. Yeah, I got it now. Thank you. So with using the digital constitutionalism framework, you can see that the Internet of Things, based on this theory, is being regulated through sort of multiple layers. We have legislation, regulation, courts. Those are all sort of what we recognize as hard law, and what most American law students spend most of their time studying. But if you look at the way that the Internet of Things functions and is actually being regulated, it's the standard setting organizations and private companies that really are driving the constitutionalism, what is permitted and and where it's going. And on the other hand, also you have now tech workers and software developers that are building in to these tech devices guidelines and boundaries that as to how these devices should be used. And these are also being supported by civil society organizations, and ultimately then end users, consumers are pushing these through the marketplace. And so next slide. So you see these different layers are all providing the framework for the regulation, the law of the Internet of Things. So the next few slides then are going through sort of other aspects of the layers that you find. You have, if you go to the next slide, the international governance, because the Internet of Things is something that's not limited to the boundaries of one nation. On an international level, you have these various layers. You have the hard law of international law, such as treaties and international organizations, and the customary law that comes with those. But you also have the important law that's being developed by international standard setting organizations, these international civil society, and then these stakeholder coalitions. So hard law has an important role, but soft law really, the softer forms of regulation are really playing an important part. If you go to the next slide. So I'm not able to see the slides very well here, but on the graphic you can see that there's this sort of interplay between traditional international, sort of hard international law organizations, and then these softer international law organizations like civil society actors. So I want to close with just one more slide, which is the final layer of law, or not really law, but control and sort of shaping of the power of the Internet of Things, which is just thinking about what academic disciplines or the people who should be involved in defining what is or is not the law of the Internet of Things. And so in law school, students think about law as just political science, human rights, traditional jurisprudential type of approaches. but the Internet of Things really is being controlled. The laws are coming out through the technology that's being developed. It's also through the way that these technologies are affecting people. And therefore, the other disciplines outside of law, outside of politicians, are crucial, and actually are some of the most important players in determining what the law is for the Internet of Things. And so finally, there's, I think, that an important role, particularly for the humanities, literature, art, theater. It's through the humanities that we see the changes that are occurring through the Internet of Things, and allow us a lens through which we determine those values on how we want the future to grow and be moved the direction that our regulations should be going. So the law and the Internet of Things, the law that's connected to the Internet of Things, is this something beyond the hard law that most American law students are learning. It really, at the end of the day, is more about soft law that that we as citizens should be engaging and participating with. So, so thank you very much for your attention. If you could go to I think the final slide I have is just the conclusion. And again, my apologies here. The things I have on my screen don't seem like they're quite connecting with what the rest of you are seeing. So just as a conclusion, let me thank you again for your attention and for allowing me to speak about this subject that interests me so much.
Thank you very much, Professor Adam, for sharing your expertise and the approach regarding American constitutional law and American law in terms of Internet of Things. Without further ado, I would like to invite Professor Bianca Richter to talk about the case study regarding Airbnb.
Thank you very much, Pedro. Thank you very much, the other professors and students who are here with us in this evening. So I'm Bianca Richter, as Pedro told you, and I'm going to talk to you about Airbnb and some legal issues regarding the relations established through this app. As Professor Adam Todd brought about the Internet of Things, all the problems and the issues are related to the lack of regulation, and it's similar to the problems I'm going to bring to discussion here about Airbnb, but in a more specific way. But let's see how it works. When discussing Airbnb or any other app designed to provide accommodation for people, we must consider that the platform supports many different relations under the same structure. For, of course, if we want to travel, like Pedro told before, we are going to consider Airbnb. But also, if you think of a short-term lease, you can also consider Airbnb. And also the hosts, they can consider Airbnb to lease just one bedroom, or to lease or the apartment, and it doesn't really about home sharing anymore. So here in Brazil, there's another perception that must be taken into consideration, and it regards hotels. Some hotels and some bed and breakfasts are offering accommodation through the platform, through Airbnb. And that happens because of the lack of regulation towards taxation. So if the relation is finished through the app, there's no tax to be paid, and it really is an attraction for hotels and Airbnbs, for hotels to use the Airbnb app. So taking that into consideration, and Diane, if you could pass to the next slide, I will thank you a lot. I cannot see it, but you're going
Sorry,
there.
I will share again. I think I had some problem here. Just 1 second, Professor.
No, it's okay, but I will just continue my speech, and in the meanwhile, I hope for the presentation to show up for the others. So taking that into consideration and the fast evolution of this form of business, it's a challenge to determine the nature of the relations built through the app. particularly if it's to be considered a lease or a hotel guest agreement. So now I can see the slides, Diane, thank you very much. In Brazil, laws regulating those matters should be passed by the National Congress. But until now, there's a total silence. There's no law about it. Considering that, it's also important to check in the courts. So how are judges ruling conflicts emerging from relations established through the app? Are they considering them like hotels or like rentals or even a third path? And why is this discussion so important? Why do we have to analyze the relation and kind of relations established through the platform Airbnb? So going to the next slide, Diane, please. When we look for decisions in the higher court in Brazil, the picture you can see there in the presentation, the Superior Court of Justice, considering the most famous app, of course, Airbnb, we can find 18 decisions. And most of these decisions refer to crimes perpetrated through the app. So people are using fake data, fake personal data to find accommodation through the app and to have access to a building under resident status. So in order to look like a guest and to commit crimes. Since most condominiums are residential buildings here in Brazil, and crimes like robbery can be committed against the neighbors. If you are Brazilian and if you were listening to this presentation, I guess that is not completely new to you because we hear a lot of stories like this. This information is important when we consider that most of people in Brazil, in large Brazilian cities, mostly like São Paulo, where Mackenzie is located, choose to live in condos, paying more for this, paying more for the security system, paying more for the camera system, the security guard systems. And how many of you, Brazilian, who are watching this, live in buildings like this and are afraid of having neighbors in the Airbnb situation who might commit a crime against your neighborhood? So although I'm talking about Brazil, this relation between the app and crimes is not something only seen here. I could find a paper written by 3 authors from the University of Florida, and they could show a link between crimes and Airbnb in the US. But what caught my eye by reading this paper is Airbnb, of course, a hot topic, but in a different perspective, depending on the country they were talking about. So let me explain it and how I saw this paper regarding Airbnb in the US, crimes and neighborhoods. So in Brazil, as I said, most of the cases that reached the higher court were related to criminals using the app to commit crimes against residents in a condo, since it's a way to become a resident and to have access to the building and to the facilities. The authors from this paper I mentioned before, on the other hand, they were concerned about the guests. They were concerned about the Airbnb guests who would be targeted as victims because they would have like valuables stolen while staying in the apartments or in the houses rented through the Airbnb. And also, since they were not staying in a touristic location, they would be exposed to more crimes. So all the concerns were related to the guests. However, here in Brazil, as I could show and tell you, the concern surrounds the neighborhood and the neighbors who are not involved directly through the app, because the criminals are the ones pretending to be regular guests to get into some condos and identify its security routine so crimes can be committed. As it's happening in all of the cities here in Brazil, some homeowners associations realized it and decided to change some rules and regulations for it to forbid the use of those apps by its residents. So next slide, Diana, please. And the link between the Airbnb business and criminality was the base of a recent ruling to a civil case from the higher court in Brazil in April this year. This case I tried to draw a little bit. When the court ruled that residential condos can forbid the use of these accommodation apps by the apartment owners. bringing up an important discussion about the private property use when there is a conflict of interest between the owner and the group of owners in a building. So the discussion is whether the collective matters should prevail over the individual right of property. By the way, by doing some research for this presentation, I found a Washington, D.C. law that takes a similar stand and sets forth that the host must provide proof that the condominium or the homeowner association approves the short-term rental. So it's a difficult question. From my research, only Washington, D.C. has this kind of law. But if you were to judge it, if you were to decide it, what would you decide? Like, should individual property rights be limited or not? This is the question the court had to decide. This discussion seems to be another one in a series of rulings that our higher court had to make in collective livings, like the ownership of pets. Could I have a pet or not because I live in a condo? Or can the homeowners association forbid the residents to use the facilities in the building because they cannot pay the condo fees, something like this. But however, this case regarding Airbnb and the homeowners association brings important outcomes that we cannot see at a first glance. We cannot see with a fast look at this decision. So although this decision is not binding, it has a persuasive force that we must take into consideration. But we must take this into consideration for similar cases, and which was the case. This case was regarding what kind of relations. So the owner of this apartment were renting the apartment and the bedrooms for different people. They were not from the same family, they were not friends, they didn't know each other. And those strangers were arriving in the building and bringing some unsafety feelings to the neighborhood, and something had to be decided, and the homeowners association decided to forbid the use of accommodation apps. Considering security concerns, the homeowners association rules and regulations to forbid the use of apps for accommodation were made, and the court stated in this case that the owner of a property who seeks to make profit should do it through rental, since it doesn't bring strangers to the building. So in the next slide, Diane, please. The main challenge when deciding cases like this is to determine whether the relation established through the app was similar to those of hotels and their guests, in which case the consumer's code should be applied for sure, or if it was like a short-term lease, in which case the rentals regulation on the need of a broker should be part of the deal, for example. So we are talking about here the third relation here that I tried to show in this presentation. It's interesting to realize that the justice of the higher court in this case says that neither known forms of relations answers well to what is done through the app. But since there's no bill passed about this new technology and its form of doing business, a decision still had to be made. And the decision was that forbidding was possible, regardless of the nature of the relation between the parties. So the decision we are talking about was not to decide about the nature of the relation. And why is that? Because it's really hard to take a position when we consider the outcomes of this decision. So for the local court, in this case, the next slide, Diana, please. What they decided? They decided that the relation established through the app is like those made in hotels, because the bedrooms were available for different people. Therefore, the use of the apps for accommodation is forbidden in residential condos. And if that position had been upheld by the higher court, the Superior Court here in Brazil, the app would have suffered a huge blow, considering that most people who use Airbnb seek for security in residential buildings, mostly in big cities here in Brazil. So the ruling did not terminate the Airbnb business, since each homeowners association is free to decide whether to authorize the use of accommodation apps or not. but we don't have the decision that it's like a hotel. The next slide, Diane, please. So you could ask to me, so Bianca, what have they decided? It's like a short-term lease. No, it's not like a short-term lease. Going beyond the decision itself, it's also important to determine the nature of the relations created through those apps, considering tax matters. And I tried to pose the two options available. For example, the next slide, Diana, please. And this precedent showed the many doubts concerning the new relations made through the app. And one of them, of course, is whether the taxation regime should be one of the hotels or one for the lease contracts, the short-term lease contracts. The lack of legal background to this polemic, which is not addressed by the ruling, justified a lawsuit filed by the Brazilian Hotels Association with the Supreme Court here in Brazil, pleading for equal treatment between hotels and Airbnbs, which would exempt hotels for paying some taxes. What was the logical thinking about it? Since Airbnb does not pay many taxes, hotels shouldn't do either. In addition, the lack of definition of the nature of those relations raises questions on the right motion to be filed once there is a lawsuit, considering that motions are designed to adapt to each conflict. So whether it's a lease or a consumer's contract, I can find the right motion to do it as a lawyer. But if I'm not sure about the nature of the relation, I have unsafety to work through this conflict. Since the legislation is not adapted to answer to new question this new technology brings, some important matters rest without an answer. Regarding taxation, so how would it be taxed? Regarding motions in lawsuit, what would be the right motion to file if I have a conflict and I need to bring it to the court? And the possibility to forbid the use of the app in residential condominiums. If the relation established through the app is to be considered a lease, and it was the last slide, Diane, if you could go back just on slide, please, the last. Yes, thank you very much. If the relation established through the app is to be considered a lease, which is not the direction pointed by the first case in the higher court, but since it's not binding and it's just one case, it can change fast. So if it's to be considered a lease or a short-term lease, we might soon face a similar discussion to that of New York City on the need for a broker to intermediate the contract made in accommodation apps. Now we can go 2 slides forward, Diane, please. And I printed 2 screens to show you that New York faces 2 class actions that I have noticed. And one of these class actions filed in New York City against brokers because they were allegedly using fake accounts to lease many real estate properties in the city, violating the city regulations about this topic. So this topic, this subject is complex and far from a conclusion. Here in Brazil, we doesn't have a law about it. We only have this ruling, just one decision, and it's not binding, as I said. But this technology challenges traditional legal institutions in many jurisdictions here in Brazil, in the US, and other countries, and economic groups around the world, of course, raising discussions which must be faced by any law student wishing to understand how regulations can keep up or not with constant changes and how some rulings, even though in individual cases and not binding, can affect business. So this was my presentation, and if you have any questions, I will be pleased to answer them. Thank you very much for your attention. And Professor Pedro, thank you very much.
Thank you very much, Professor Bianca Richter. If you mind, we would like to take this opportunity to open the floor for questions for the students. If they want to address any question either to Professor Adam or to Professor Bianca. And then we can also later on move with the presentation regarding our joint degree program. Students, feel free to ask.
Pedro, if I may, I have one question to Professor Adam. And the question came out of his presentation, of course, Professor, but also from the studies I made through Airbnb app and some regulations about it in the US. I could realize that each city has its own regulations about Airbnb, and it's usual in the US. But when we consider the Internet of Things, and as you told us, the need for a common regulation for it to work, how do you think it's do you think it's going to be the future? Like, do you think this solution, this conclusion about constitutionalism regarding the Internet of Things is an attempt to give a unique answer to the problem?
Let me answer your question in two ways. First, so with federalism in the United States, the regulation of the Internet of Things, unfortunately, is not being regulated on a federal level. So there is no comprehensive federal regulation, even, for example, relating to the Airbnb apps in the United States. There is no comprehensive sort of regulation that you can find for all the states. And then, but you do find within each state, some states have comprehensive regulations for the whole state itself. But then there are some states that don't have comprehensive regulations in their state, and so then it's regulated on a municipal level. And so, with something like Airbnb, you find that most states, the regulation of Airbnb and whether they have to pay additional taxes or whether there's certain regulations that they have to follow. And for example, in Ohio, where I live, that's done on a municipal level. Each town has its own different regulations, and then in many towns you have homeowners associations like you were looking at as well. So that's in the United States, I would label this as fragmented. The regulation of Airbnb is one that there isn't clear coherency on a federal level, and instead you find sort of regulation occurring on local levels, and if you're looking for a coherency or a constitutionalism, the amalgamation of all of the lack of regulation on one hand on the federal level, the different types of regulations you're finding on municipal level, all of those things come together to create a form of regulation, and sort of and expectations of the way that Airbnb should be functioning. Actually, I think a better example, rather than Airbnb in the United States, would be Uber. The taxi company Uber. A number of states have been regulating Uber in terms of the apps and the way that Uber should be functioning. But then most regulation relating to Uber is based on municipalities. But there's significant issues relating to labor, whether an Uber driver is an independent contractor or an employee, what type of taxes should be paid, whether they should be paying taxi brokerage fees. So right now, things are in flux and are changing because I think there is some consensus in some states to create comprehensive regulation, but that it hasn't gelled together as of yet. So right now, my frame of digital constitutionalism is the regulation is occurring on all these different levels. One important level of the regulation or the functioning of Uber or Airbnb is the marketplace, the way that the consumers are responding to what they want the app to do, what they want the company to do, what they want them, and I think that part of the regulation is particularly important as the technology is so new. But the consumers then also express their desires to the company, but then also to their municipality levels, and so you have this sort of layering that's creating, at the end of the day, what to understand where the regulation is, you need to be looking at all these different layers. So I don't know whether that answers your questions, Professor Richter.
Thank you very much.
Thank you very much, Adam, and also to highlight the importance of a transnational law approach. That is what our program aims to offer to our students. And this analytical and comparative approach also between how international systems work regarding who regulates what and how. It's what makes the difference in terms of professional capabilities. If there is any other question, I would like then to invite Professor Margaret to talk a little bit about the program and to see if our students have any questions regarding the admission process.
Oh, thank you, Pedro, and Professor Richter and Professor Todd. I love this topic, so I really enjoyed both of your presentations, and I don't think I'll look at Uber or Airbnb the same way again after thinking through the legal implications. So, and thank you to Mackenzie for the opportunity to be here tonight. I know we're a little bit over the hour, so I promise I won't take too long. I'm Margaret Ioannidis, the director for the online LLM program at University of Dayton School of Law. That simply means that I work with all aspects of the program, from recruitment to the academic piece, and I look forward to answering any questions that students might have about the online LLM program. We can move to the next slide. I joined University of Dayton in 2018. Prior to that, I had been working exclusively with online LLM programs since 2014. I'm also a licensed attorney. And when I was brought to work with University of Dayton, the purpose was to develop a fully online LLM program. University of Dayton School of Law is an American Bar Association accredited law school located in Dayton, Ohio, which is in the Midwest in the United States. And historically, the university offered a fully on-campus LLM program. And after I joined the university, we were able to develop a fully online option for students as well. So since 2019, University of Dayton has been able to offer the same LLM degree that had been offered on campus in a fully online format. And so by doing so, we are able to expand access to that LLM program to those students who might be working overseas, might be pursuing other degrees overseas, or who simply might not have an interest in moving to the United States and taking 1 to 2 years out of their lives to pursue an LLM degree. Our online LLM is focused on US law and legal practice. So we can move to the next slide. So we're really excited about the partnership with Mackenzie, and we've included some highlights here. My colleague Walter Hawes, we waved at the beginning of the webinar. He and I work closely with students who might be interested in applying to the program from Mackenzie University. And so with the partnership, there's several advantages. Number one, students who are interested are able to start our LLM program while still working towards the bachelorette degree. So for those of you who are pursuing your bachelorette degree, as long as you've completed 7 semesters of coursework, you are eligible to apply for early admission into the LLM program. So what that means is you are then able to pursue both degrees at the same time. If you are pursuing your master's degree or postgraduate degree in political and economic law, so whether master's or PhD, you are able to start the LLM program at any time. Under any of these scenarios, students are able to get credit recognition from the studies at Mackenzie University and be able to complete the LLM program with 20 rather than 30 credits. So 1/3 of the credits required for the degree, you don't have to complete. We are able to recognize the credits based on your studies at Mackenzie University. So that reduces from a total of 12 courses to 8 courses, the amount needed in order to earn the LLM degree. It also means rather than having to take 12 months to complete the program, you can complete within 8 months, which would be 2 semesters. Next slide. So we also have a guaranteed scholarship for students applying through this partnership. And so that scholarship is applied per credit that students take. So it's $762 per credit. And it applies whether, at a minimum, you will complete 20 credits to earn the LLM degree. But for those students who want to complete 30 credits, and all of the courses, you're able to do so as well. So we honor this per credit scholarship of $762 per credit up to a total of 30 credits. For those who are interested in completing the program as quickly as possible and taking full advantage of the credit recognition, you are able to complete the LLM with 20 credits, and the total tuition cost would be $9,500 US. That's paid as through the course of the program, so as you complete the program each semester. Next slide. I mentioned earlier that the online LLM program is the same LLM degree as the one offered on campus in Dayton, Ohio. And so as you can see, the diploma would be the same. It does not reflect the program as an online program. Next slide. I mentioned that the online curriculum is focused on U.S. law and legal practice. So I wanted to include the course list here. As we mentioned, students are able to get credit recognition of up to 10 credits, and that would be 4 courses in the program. Students would then complete the remaining 8 courses. Of those, 5 are required and highlighted in green here, and then the remaining 3 can be selected from the other course options. Next slide. So we are accepting applications now. Our next semester begins on August 23rd. The deadline is 1 month before the semester begins, so by July 23rd. We understand that many of you are taking exams right now, so we thank you for taking the time to join us tonight. We wish you luck on your exams. Once you've finished up those exams, please feel free to reach out to Walter or myself. We'd be happy to answer any questions that you have. And next slide. Before we move into questions, I wanted to include our contact information here. One more slide. We wanted to invite everyone to our Law in the Americas webinar series. We've got one, if you can advance one more. Thank you. We have 2 upcoming webinars. These are hosted by the University of Dayton School of Law. We bring together thought leaders on different legal topics, and our next event will be June 18th, focused on copyright law, and August 19th, copyrights and COVID vaccines. Also, we have a seminar on law and technology happening on campus, or not on campus, happening on June 11th. Normally it's done on campus. This year it will be live streamed, and it is free for students to participate. So if any of you are interested, this is a full day event. There are amazing speakers in the field of law and technology. So if you thought this presentation was interesting, I would encourage you to sign up as well for and register for that event. I know I'm already registered for it. So with that, I'll turn it back over to you, Pedro.
Thank you very much, Margaret, for the presentation. I would like also to thank you once again, Professor Adam and Professor Bianca. It was a bright night for our evening for our students and for our partnership. I would like to open the floor for questions, and I would also like to highlight that today we have published our Law in America Fellowship Program. which entitles one scholarship for a Mackenzie Presbyterian student in accordance with the eligibility requirements that are published in our open call. If there is any doubt or question or inquiry regarding the fellowship, please address an email to coi.alunus@mackenzie.br. Professor Marianne and myself can also be found to help you out with any question that might arise. So please, students, feel free to ask us any question regarding either the keynote speeches that were presented tonight or the program itself, or even regarding the scholarship program.
Hi, Brooke. Sorry.
Yes, please.
Can you hear me?
Perfectly. Loud and clear.
Yes. So, hi, I'm Beatriz Alvarez. I'm from Mackenzie. And I would like to thank you for this webinar. I loved learning about the leases and the issues about Airbnb and Uber. And I will also like to thank you for the scholarship program. It's amazing. So I have only two questions about it. The first one is the motivation letter must be in English and Portuguese, and the translation can be simple, or maybe it must be approved by some teacher, some professor. And about the exam, in the site, the website, it says that should be the TOEFL and the IELTS, but I don't know if we have time to take this test. So I would like to ask you if we can take the Mackenzie's test to fill the program, and
Margaret?
that's it.
Sure. Would you like me to field that one? I can.
All right. I can also, but
Sure.
Phil, please.
Okay, sure. Thank you. Thank you. Yes. Well, yes, please feel free to apply. If there's a Mackenzie, we accept the TOEFL and IELTS. Those are the preferred exams. But if you have alternate proof of English proficiency, we're happy to consider that. And it sounds, I mean, you're speaking in English, or you have great English skills. So I would suggest if you have a Mackenzie exam that you've completed, you may submit that in lieu of the TOEFL or IELTS.
Thank you.
Thank you.
And regarding the personal statement, it's not required that a faculty member sign it for you. It's just the same personal statement that is required for your admission process at Dayton School of Law. So it's not a recommendational letter. It's just a personal statement. You could save some time by writing it on English, because then you would be able to use it for the admission process if you are awarded with the scholarship.
Okay, thank you, Book.
And I would encourage you for the personal statement to highlight your interest in law, and specifically in the area of transnational law. And so I know that the presenters today discussed how the law of Internet of Things is really transnational in focus. There are other fields similar, to law and technology as well. So if you can just articulate what your career goals are and how you see this LLM and that understanding of U.S. law and legal practice helping you advance professionally, that would be really helpful.
Thank you, Margaret, for the
Thank
tip.
you.
I will apply.
And Beatrice, please get in touch or email us, that we will gladly help you with the process.
Thank you, Book. And thank you all for the tips and the program. It is amazing for us students who can't afford the program to have this chance. I loved the webinar today because I love technology, and I think the distance and the language can't be an issue because technology is everywhere and the law must follow it. And I'm amazed with the program. Congratulations. And I'm really happy to apply for it.
Thank you.
Caroline?
Hi, I'm sorry if it's busy, but in my workplace, I have two simple questions. First is if you all accept the FCE certificate, and the second one is that I did an internship, an exchange program with Mackenzie, and if I could use some credits that I did in Barcelona in this university, or you can only accept the Mackenzie subjects.
Okay, so, oh, go ahead, Pedro.
Yeah, that's a hard one. Hard one. Would you like to answer regarding the proficiency, the English proficiency, and then I can
Sure.
talk about the credits that she studied at Barcelona.
Sure, I would be happy to. So I think, yes, so for the English proficiency, again, that would be an alternative proof of proficiency, so we would accept that. And I would say for the credit recognition, if somebody has already graduated with the first degree in law with a bachelorette, then you automatically get 10 credits of advanced standing because you have that degree, regardless of where the courses were taken. If you are still pursuing your bachelorette degree, we didn't include it in tonight's presentation because there were time limitations, but we have a select courses that you're able to apply, transfer, and credit towards the LLM degree.
I'm just putting at the chat, Carolini, where you can find the information regarding the credits. You will see that there are 4 credits that are accepted: Laboratório de Conciliação, Direito Ambiental, Contratos Internacionais e Processo Tributário. If that is the case, then you can use those credits being a student at Mackenzie Presbyterian University. If you have already fulfilled this credit in Barcelona and your administration or academic coordination didn't, up to now, granted you the credits, you should ask them to recognize the credits that you were enrolled at Barcelona. Doing so, you will be able to use the credit. But there is a specific set of course subjects that can be used in this program, okay?
Okay, thank you.
Rodrigo?
Hi everyone. I have 3 questions. The first one is if there are plans to open a new type of scholarships, for example, a merit-based one. The second question is considering the time zone. I would like to know if you guys have schedules for the classes, and I'm sorry for my delay, but I have a question for Professor Adam. Here in Brazil, we have several cases that cover the Internet of Things, and one of that is cryptography. I am doing a research about it, so I would like to ask you, because in the end of the day, I remember that you said that there in the United States, you have a multi-layered exercise of power. But here in Brazil, in my impression, in the end of the day, who will decide how it will be regulated, the situation is the Supreme Court. So thinking from a comparative perspective, here in Brazil, this multi-layered exercise of power is not that balanced, you know. So I would like to know if in the United States, the regulation of issues like that, issues like this by these powers is balanced. So thank you guys, and I am really happy to participate.
Adam, I'll defer to you to cover the legal question first, and then I'm happy to field the other two about the program. Oh, you're on mute, Adam.
Thank you for that question. Very briefly, the advantage, I think, of Brazil's approach to regulation of the internet and the Internet of Things is, I personally feel like, is preferable compared to the fragmented method you find in the United States. And it's, if my understanding is correct, it's more comprehensive. It's similar to the European Union's privacy directive, the European Union's more sort of comprehensive approach. The drawback in the United States is, the lack of coherency allows for violations of privacy. The only benefit that you could point to for the multi-layered, less coherent form of regulation that you find in the United States is that it does allow for greater adaptation and for promotion of new technological change, and also allows for societal change. We don't know really how we are as a people going to be changed by these new technologies, and it's arguable that maybe we will change for the better. I'm not convinced that we will be changed for the better, but there is that question. I would prefer a more regimented approach like you find in Brazil. Personally, I'm more fearful of what the internet and the Internet of Things will bring, but I think the answer to the best way to regulate is still up in the air. Certainly within the United States, there's not an agreement as to how to do it.
Thanks, Adam, and I'll go ahead and field the other questions. I'll add one comment too. I did not mention in my portion of the presentation, but for students pursuing the LLM degree online, California and Washington State are two potential bar opportunities, and California, as Adam has mentioned, is at the forefront of regulations for law and tech. So again, for those of you interested in that field, you might find that interesting. So Rodrigo, for your first question, no, we don't anticipate additional scholarships for merit-based. The reason for that is we already are discounting very, very deeply through this partnership. In fact, students that independently would reach out about the program would have to complete the full 30 credits. The maximum scholarship that would be awarded is up to 50% off. And so reducing to 20 rather than 30 credits and offering an additional 70% discount on the scholarship is probably the maximum that will go. In fact, that is locked in only for the students starting in August and in January. So I just wanted to address that. The second question related to the time zone is a really good one. And so I did not give enough background on this. The program is fully online and asynchronous. And so that means that the lectures and content are pre-recorded. Now, we do have live components using Zoom. Professors have weekly office hours. In addition, they have at least 3 full review sessions per semester where the whole class comes together. But those are all optional, and those are also recorded and made available for students who can't join live. We have about 60 students in the program right now in different time zones all over the world. And so we found it is nearly impossible to find one day in time where students are able to, to all attend live consistently. And so when professors have their live sessions, they try them at different times. That way students, regardless of where they are able to join at some point. So it is asynchronous. And then also that extends into the exam. So all of our exams, the midterms and the finals, are offered online. They're proctored online, and students have a 1-week period. And any time and any day during that 1-week period, students are able to take their exams. So if Adam and I were in the same course, Adam might choose to take the exam on Monday morning at 8 a.m. I might choose to take it Wednesday at 5 p.m. and that would be fine because the exams are all proctored online. So we try to give a lot of flexibility. Most students in the program are either pursuing another degree simultaneously or they're working full-time. That's why they have such a strong interest in completing a fully online program.
Thank you, Margaret.
Yeah, thank you, guys.
Thank you.
Now we have Isadora Meyer.
Hi, good evening. My name is Isadora. First of all, I'd like to thank you all for the incredible presentation. Secondly, I have a question. I took a Cambridge proficiency test 5 years ago, so it's a bit outdated, and I'd have to take another one. So I'd like to know, how old does the proficiency certificate should be to apply for the program? Thank you.
That's a great question. So generally, we would say within 2 years. Having said that, because of the scholarship deadline, I think if you have one that's 5 years old, you're not able to complete another one, I think that we are willing to, to consider that. Typically, what we do in the admission process is if somebody does have an assessment that's more than 2 years old, we then schedule a follow-up video English proficiency assessment, because if your proficiency was 5 years ago, it doesn't necessarily mean that your proficiency is at the same level today as it was 5 years ago. It may be better, it may be worse, and so that's usually the process that we follow. But based on the timeline, I would suggest go ahead and submit the assessment that you have if you're not able to get another one in time for the deadline for the scholarship.
Okay, jumping in this question,
Yes.
Margaret.
Mm-hmm.
There's also, I've just copied at the chat. So there's also, Isadora, you can schedule an exam at a Mackenzie Language Center. So they're ready, and they're ready to offer you an exam whenever you're available and at your most convenient time. So
Perfect.
there are ways. We are here to make things happen. So even with the 5 years old time, even though your Cambridge is 5 years old.
Okay, thank you.
Any other question? Not. I would like once again to thank you for your presence. We will have another 2 webinars. The next one will be on the 24th of June. And thank you for taking your time. Professors, special thanks for you. Dayton School of Law representatives, thank you also for taking your time to answer our students' questions. And Mariana Baeta, also thank you for all your support.